A very good morning and welcome to the 11th meeting of the Criminal Justice Committee in 2026. We've no apologies this morning and we are expecting to be joined by Pauline McNeill MSP and Katie Clark MSP shortly. So our first item of business today is an oral evidence taking session on a legislative consent memorandum and a supplementary memorandum for the UK Government's Northern Ireland Troubles Bill. In addition to the Cabinet Secretary for Justice and Home Affairs, I welcome Nicholas Parton, Veterans Unit, and Claire McKinlay, Solicitor at the Legal Directorate at the Scottish Government. So welcome to you all. And I refer members to paper 1. And I intend to allow up to 30 minutes or so for these items. So can I begin, as usual, by asking the Cabinet Secretary to make some opening remarks on the LCMs. Cabinet Secretary.
Thank you, Convener, and good morning. And I'm grateful for the opportunity to be with you here this morning to speak to the UK Government's Northern Ireland Troubles Bill and the associated legislative consent memorandum. As committee will recall, the previous UK Government introduced the extant Northern Ireland Legacy and Reconciliation Act in 2022. At the time, the Scottish Parliament withheld consent to the Act. This was due to a number of factors, including the Bill's potential impact on the powers and the independence of the Lord Advocate. I view that it would not make it easier for victims of the Troubles to obtain justice, and the potential breach of compliance with Articles 2 and 3 of the European Convention on Human Rights entailed by the immunity provisions it contained in relation to those who came forward with information. However, on that occasion, the UK Government chose to proceed with the bill and it received royal assent in 2023 in the absence of the Scottish Parliament's legislative consent for relevant provisions. This context is useful to bear in mind when considering this bill, which repeals and replaces elements of that Act. The changes this will make include, firstly, establishing a UK-wide Legacy Commission whose core function would be to investigate conduct causing death or serious harm which form part of the Troubles. This replaces the body established under the previous Act. It also establishes procedures for investigations by the Legacy Commission and amends arrangements for inquests in Northern Ireland into Troubles-related deaths and requires the Legacy Commission to produce a historical record of deaths linked to Troubles-related conduct that were not otherwise investigated. Our officials have had extensive engagement with the Northern Ireland Office over the bill, which I'm thankful for. Our principles in respect of the new bill are clear and have not changed. Those who have suffered during the Troubles should be able to obtain justice, while those who have committed serious offences during that time should be appropriately held to account. In seeking to achieve this new bill should avoid or at least limit as far as possible potential detrimental impact on the Lord Advocate's independence or constitutional position. It is our conclusion that this bill, while imperfect in places, still represents a significant improvement across all these areas of principle. The proposed bill has a lesser impact on the Lord Advocate's independence than the existing Act and, importantly, includes an express confirmation that provision of information about Troubles-related deaths to the new international body established under the bill does not result in immunity from prosecution. Immunity in respect of Troubles-related conduct was previously granted under a contentious provision within the Legacy Act that MPs have voted to repeal by remedial order due to its incompatibility with the European Convention on Human Rights. This position reflected in the new bill aligns more closely with the Scottish Government's views regarding the rights of victims and the need for accountability for those who committed trouble-related offences. And the position of the Scottish Government is therefore to recommend that Parliament give consent to the bill as introduced in full.
Thank you very much indeed, Cabinet Secretary. So before I open up to questions, I have to say I am pleased that I think it's clause 28 relates to matters of investigations of deaths, and clause 28.10 allows the Lord Advocate to request the new commission investigates where there are where there's evidence of conduct potentially amounting to an offence under the law in Scotland. So I'm pleased to see that included. I wonder if I can maybe just ask a general question, and it relates to the sort of function of the Legacy Commission, which is firstly investigating conduct causing death or serious harm, which formed part of the Troubles, and or conducting inquisitorial proceedings into the circumstances of certain deaths. I think it's really more just for clarity for the committee. I was wondering if you can just perhaps outline a little bit about the distinction between those two functions.
So I'll ask officials to come in a moment on the detail of that, Convener. I suppose the broad point I would wish to make is that the Crown Office and Procurator Fiscal's view on this legislation is, as you'd expect, important. And, you know, what I will, go back to is that this bill has a reduced impact on the Lord Advocate's powers as, head of independent prosecution in Scotland. I mean, it is acknowledged that the provisions, do continue to encroach, but there are either no worse than the existing position or are an improvement. So it's important that we consider the context of the current UK legislation when we were considering this bill, and the removal of the immunity provisions obviously addresses the ECHR incompatibility. So I don't know if this is policy or legal.
Claire, do you want to come in first, or shall I give it a go? I was going to ask actually for the distinction you're asking about, to be just for me to be reminded of what it was again. Sorry.
Just to ask, obviously, the sort of main functions of the new Legacy Commission, core functions are investigating conduct causing death or serious harm that was associated with the Troubles, and conducting inquisitorial proceedings into the circumstances of certain deaths caused as part of the Troubles. So it was really just to help us understand what the kind of distinction is between those two functions.
Between investigation and conducting inquisitorial proceedings.
Yeah.
I mean, I can come in.
Yeah, thank you, Claire.
One distinction is that the investigations can relate to a wide range of criminal conduct, not only conduct causing deaths, whereas inquisitorial proceedings are restricted to the investigation of the circumstances of certain deaths. I don't have details to hand on, the allocation process for example, a death, which proceedings it would go to. I do know that the bill makes detailed provision for different procedures to apply, obviously, to each process, and different members of the Legacy Commission with different functions to conduct those. Certainly we could look to provide a bit more information to the committee if that would be helpful as a follow-up from this session.
That would probably be helpful, although we are limited in time, but just to help our understanding of the sort of provisions in the bill. I wondered if perhaps the opportunity for inquisitorial proceedings perhaps flowed from this outcome from an investigation, if you like. But it's maybe something you could sort of clarify by way of follow-up. That'd be helpful.
There's no problem at all with that, Convener, and of course we'll do that. But it is important to emphasise this isn't a Scottish Government bill; it's a UK Government bill, and our active interest in this is how it encroaches on devolved matters or otherwise.
Mm-hmm. Thanks very much. Just one final question from me, and it relates again to some of the information in the memorandum, and it seems to set out that certain clauses would confer powers on UK ministers to act in devolved areas but make no provision for the involvement of Scottish ministers. So if I'm reading this correctly, the rationale for the government still recommending the LCM as agreed is that these clauses are unlikely to be applicable in Scotland due to there being no known troubles-related deaths or serious injuries that we're aware of in Scotland. Just wondering if we can be sort of sure that that would remain the case, and that in the passage of time we wouldn't find ourselves in a position where there maybe were cases sort of uncovered.
So it's an important point, Convener, and is a matter that we have continued to engage with the Crown Office about, and obviously this legislation relates very specifically to events in the past that have taken place in Northern Ireland. And of course there could be individuals from elsewhere in the UK involved in those events. But in terms of events in Scotland, and we have checked with the Crown Office, who I believe have checked as far as is possible, that there are no known deaths or major injuries that have occurred due to the Troubles in Scotland. So therefore the impact, for example, on the Lord Advocate's powers is believed to be minimal.
Yeah, okay, thank you for that reassurance. Okay, thank you. So I'm going to hand over to Liam Kerr.
Thank you, Convener. Good morning, Cabinet Secretary. The Veterans Commissioner for the Veterans Commissioners for Scotland and Northern Ireland and Wales, I think, have expressed concerns around veterans' protections and lawfare and historical narrative revision. Given that, and in any event, has the Cabinet Secretary sought the views of the Scottish Veterans Commissioner? And if so, what's her view?
So I have not had any direct engagement with the Veterans Commissioner on this matter. I have on other matters in the past. What I do know is that Mr Day, the Veterans Minister, continues to engage with the Commissioner on a whole range of matters, and I am aware that Mr Day is aware of the concerns expressed by the Veterans Commissioner in Scotland and elsewhere, and I am of course aware of the representations that all Veterans Commissioners have been making to the UK Government with respect to their bill. I'm also aware that there is a commitment from the UK Government to continue to engage with the Veterans Commissioners, as we would all expect, and there are proposed protections for veterans, for example, a presumption for remote evidence, so people don't have to travel to Northern Ireland, protections against repeat investigations, a right to anonymity, and also that right to have the veterans' voices heard, and that the bill has a statutory advisory group, and that there are other protections on the grounds of age and welfare. So I just provide that by way of information as opposed to commentary, because this is not a Scottish Government bill, it's a UK bill.
Grateful. And have you had, Cabinet Secretary, any direct meeting, or is there any correspondence you can share with the Secretary of State for Northern Ireland on either the substantive bill or this LCM?
So I will check with that, Mr Kerr. I know that officials have had a lot of engagement with the Northern Ireland office, and I don't actually know what exists in terms of correspondence, but I will go away and look at that, and if there's information that we can share, I mean, there wouldn't be any reason for us not to share that.
I'm grateful. And final thing for me at this stage, you'll see my theme developing. The Scottish Government has had verbal engagement, I understand, with Police Scotland about this. but there's currently no written record of that engagement. Have you met and discussed this with Police Scotland? And in any event, is there any point at which we can see the written note of what their view was from that verbal engagement?
So I've not engaged with Police Scotland directly, person to person on this, but again, I believe officials have, and again, I can check what information exists on records.
Very grateful. I might come back in later, Convener, but...
Okay, thank you very much. Any other members wish to come in before I bring in Mr. Mountain? No. Mr. Mountain, would you like to come in?
Yeah, thank you very much, Convener, and I'm very grateful that you've allowed me to join your committee this morning. I think it's the one committee I haven't joined in 10 years in the Parliament. And if you'll excuse me, Convener, I just want to make a declaration up front so everyone knows exactly where I'm coming from. I was a soldier for 12 years. I did not do an op banner tour in Northern Ireland, but a lot of my friends did do op banner tours and served in Northern Ireland. I had friends who died there, and I've had friends and colleagues who were blown up in my regiment in London in July 1982. Anthony Daly, Roy Bright, Jeff Young and Simon Tipper, who were all blown up with their horses while they were carrying out ceremonial duty. And I've had a colleague, Dennis Hutchins, who was dragged back to answer charges dating back to 1974 in 2020 when he was suffering from a terminal illness and died before his trial was completed. So I guess I would say that I'm emotionally and for a variety of reasons invested in this bill. My question is that just say John Downey, who was given a on-the-run ticket, who was one of the members who planted that bomb in London, was living in Scotland, would the Legacy Commission set up by this bill, which the government in Scotland are supporting, be hauled into justice in the same way that Dennis Hutchins was for an event in 1971?
By the last part of Mr. Mountain's question, I just want to be clear about what you are asking.
Well, a Legacy Commission is being set up by this bill, and you are supporting the bill. I want to know if that Legacy Commission will look at both sides of the argument, unlike what's happened in the past before the 23 bill came up, where it was just soldiers and servicemen and women who were hauled before the Legacy Commission. Will they actually haul forward those people who were involved from the... I'm going to be careful on my terminology here, who were on the other side in front of that Legacy Commission? That's my question. Do you think they will be, Cabinet Secretary?
Okay. I will ask officials to come in the detail of that point, Mr. Mountain. I suppose the only point I would want to clarify, what I am taking through Parliament is a legislative consent motion around the aspects of a UK government bill that impacts on devolution. In terms of the operation of the Legacy Commission, it is a UK-wide commission, and actually it's been established as I understand it, an international body. Nick, is there anything you could add about the functioning of the Commission?
Well, certainly my understanding is the Commission can take information about any serious criminality that's occurred in relation to the Troubles. So that would include, obviously, information relating to the sort of individual you describe, Mr. Mountain, in terms of someone who's on the other side, as you put it, of the debate, of the conflict as well. So my understanding is that the Commission could look at both sides.
Okay, and Convener, I've got one more question, if I may. Is Cabinet Secretary, what I do know is that when we ask people to serve for their country and we throw them into harm's way, we have no idea what that's like, or the majority of us have no idea what that's like. Decisions which are made in split seconds, when things, if you'll excuse the vernacular, go batshit crazy. You look left, you look right, you make sure those people on either side of you are right, and then you do everything in your power at that stage to protect them. I struggle to understand how setting up a commission who sit in a warm room with cups of coffee and water and adequate food can look back dispassionately and make judgments on what people did at the time, which obviously at that time was what was right to do. hindsight's a wonderful thing. When you have things being thrown at you, you don't have that view. So I want to know if the Scottish Government are content that this bill will protect soldiers and servicemen and women from all the services who've done exactly what we've asked them to do in difficult situations, and for most of us, impossible to understand situations. Cabinet Secretary.
So, Mr Mountain, I mean, I, like many people who have never served in the front line, will not have a comprehensive or a complete or a lived experience of what's that like. Like many Scots, I have a close family member who has served, but of course my knowledge and information about that is only second-hand, although it is a close family member. And from my own engagement with the veterans community and my constituency, I'm well aware of the long-term impacts, socially, emotionally, physically, that serving your country and being prepared to make the ultimate sacrifice for your country, and the impact that that can have, not just on those who serve, but on their loved ones as well. I come back to my position in that I'm being asked to give a view on legislative consent in terms of how this bill impacts on devolution. And I suppose there are three principles that I have to come back to. One is, does this bill improve or avoid or limit the detrimental impact on the Lord Advocate that I was previously concerned about? And my view of that is yes. And the other two principles are principles that I think apply to everyone, whether you've served or whether you're a civilian, in relation to the Northern Irish Troubles, and that is that those who have suffered should be able to obtain justice, and those who have or believed or alleged to have committed serious offences have to be held to account. And I think those are principles that have to apply to everyone in terms of how you've been affected by the Northern Irish Troubles or how you've served. So we have to be fair to everyone, and it will be for MPs. I mean, we all have MP colleagues to scrutinise the detail of that bill and to ensure that the Legacy Commission, which is established as an international body, is robust and fair to all involved.
And thank you, Convener. I'd probably share the views I do share the views of the Cabinet Secretary. It should be equal for everyone. My fear is that this bill makes it unequal for those who have responded to the call of their country to do what they're asked to do. And, I mean, I don't need to mention it was 3 Scottish soldiers, young lads, who were hauled out of their barracks and shot and killed. There's no one being called to justice for that. And therefore, whether the government, my view, Convener, is that giving consent to a bill that doesn't see justice for both sides is fundamentally wrong and flawed. And I would urge the committee to reflect on that when I know they will give this the serious consideration it needs. And thank you for allowing me to make my point this morning.
Okay, thank you, Mr Mountain. Okay, so if no other member wishes to come in... Oh, Liam.
Thank you, Convener. Cabinet Secretary, just a very quick one. What happens if this committee doesn't recommend consent to Parliament? What happens if Parliament doesn't consent to the LCM? And when do you anticipate Parliament will actually be asked to give its consent to this LCM?
So, if committee and if Parliament doesn't give consent, if I can refer you to the views of Parliament when we voted on the Legacy Act to withhold consent, that the UK government proceeded anyway. So I think you've asked that question, Mr Cairn. You know the answer.
And when do you think that Parliament will be asked the substantive question?
Actually, I'm not actually sure about that.
Presumably it'll be the next session, though, will it?
Presumably, but I've not got past this week, never mind next week. So
I'm grateful. Convenient.
Okay, thank you. Jamie Hepburn.
Thank you, Convener. I hadn't actually intended on coming in say anything on this, but it's more an observation than anything. I take on board the points that Mr Mountain has made, and it's perfectly legitimate to take a wider view on the wider bill. I suppose I would just observe, we need to remember we're being asked really to look at a narrow part of the bill in terms of legislative consent, and it does strike me as though it's around trying to make sure that we protect the independence of the Lord Advocate, which is something that I think we should all reflect on as an important thing for us to do.
Any other member wish to come in? If not, that concludes our evidence session. And I'll now allow a short discussion in the committee where members, if they wish, can give me an indication of their views on the LCM before I move to the question of consent and any recommendation to Parliament. So, Liam Kerr.
Thank you, Convener. I'm not sure if this is a separate part of the proceedings, but I don't think this committee should consent to or should recommend to Parliament at this stage that this be consented to. And I have two reasons for saying that, just rooted in the questions that I was putting to the Cabinet Secretary. And that's to do with and I'm referring to the Cabinet Secretary's letter of 13th of March, which is very helpful. I'm grateful. But it says, it concedes that the bill's timetable, the substantive bill, the timetable remains uncertain. And I'm looking at the supplementary LCM at paragraph 26, and it was something that the Cabinet Secretary referred to when I was asking about the Veterans Commissioners. Because the supplementary LCM says at paragraph 26, the Veterans Commissioners welcome an indication from UK Government ministers that further planned engagements with ministers should result in changes to the legislation. So something could well change. My second reason why I don't think this committee should recommend agreement at Parliament at this stage is because what we've heard, and I make no criticism of the Cabinet Secretary here, it's just an observation, but we haven't got full consultation here. I don't know what the Scottish Veterans Commissioner thinks about this. I don't know what the Secretary of State for Northern Ireland thinks about this. I don't yet know what Police Scotland thinks about this. The Cabinet Secretary was very helpful and said, look, there might be something there and I'll send it in. But I feel like I'm looking at this in a vacuum. I haven't got the information, and I'm being asked to make a recommendation to my colleagues in full Parliament. And that concerns me, because ultimately I don't think that Holyrood, I don't think our Parliament should be giving a blank cheque to the UK government. I don't think that we need to give consent now, because as the Cabinet Secretary just said, I think this is going to be heard in the next session in time when more details will have become available. So I don't think we should do this. I don't think we should make this recommendation without knowing exactly what we're being asked about. And given that I think this will go into the next session, we seem to have time to get that information, or the next committee will have time to get that information and make a fully informed and fully considered decision and thus recommendation to our Parliament.
Okay, thank you very much. I'll bring in Fulton McGregor and then I'll bring in the Cabinet Secretary to respond. Fulton McGregor.
Thank you, Convener. I do think that Liam Kerr makes some really valid points there. However, I also disagree and think that we should agree and make this recommendation to Parliament today, because it's obviously a very serious and sensitive issue, and I wouldn't want the Scottish Parliament's role in that to be the one that's holding anything up. However, I think that Edward Mountain has made a strong case today in terms of his own personal experience, and he's brought to the table something that probably the rest of us actually don't have. And I wondered the question I was going to ask, which predates when Liam Kerr came in and maybe changed the sort of angle of the conversation. But the question I was going to ask was, is there anything we can do when the committee approves it, if that's the decision that we take, or agrees to it, to make reference to what we've heard today from Mr Mountain and make those views known to whoever's relevant in the UK Government.
Thank you very much indeed. Any other members want to come in? If not, Katie.
I'm not sure if there's going to be another opportunity. So I'll come in now if there's no more opportunity. I had been looking forward to hearing from the Cabinet Secretary in terms of timescales and whether this is something that needs to be dealt with today. I would like to thank Mr Mountain for coming along today and putting his experience on the record, because I think it has helped to put this relatively narrow legislative matter into its wider context. Obviously, the purpose of the Legacy Commission is investigate conduct causing death or serious harm, which form part of the Troubles, and to conduct proceedings investigating the circumstances of certain deaths, and that would be something that I would support. But I think clarity around the very narrow nature of this LCM is helpful. I'm very pleased that the issues round about the independence of the Lord Advocate were resolved, because I know the committee was extremely concerned about those issues when we discussed the matter previously, and that was the major focus, and I'm very pleased that that seems to have been settled in a satisfactory manner. But if the Cabinet Secretary was able to give some information as to whether we really have time to get further information, or whether this is something that really should be dealt with now and before the elections.
Cabinet Secretary, I'll bring you in just to respond to the points made.
So there will be further legislative consent motions, because royal assent is expected, or the aim is around autumn this year. And I am aware that the commissioners, plural, have been engaging directly with the Northern Ireland office on the effects of the bill. And they did state in November that UK ministers had indicated that further planned engagements, and that ministers and senior officials would, work on changes to the legislation that would provide an improvement for the veterans community. Now, obviously, I'm not involved in that or in control of that. So it is our current understanding that the UK Government will introduce a further package of amendments at committee stage to build upon the existing safeguards that are currently in the Troubles Bill. And we'll consider, from a government perspective, those changes when they are made. So there will be further LCMs, and I hope that would reassure colleagues that this isn't my view is that we should proceed with this today. Obviously, committee will come to their own view, because it is a very discreet ask that is being made. I think we do, need to welcome the improvement in relation to the Lord Advocate's position, but also in terms of the removal of the immunity from prosecution provisions, which removes the concerns around ECHR, excuse me. And the other point, I think my final point, convener, is that I suppose in terms of the here and now, the bill includes protections that don't currently exist, and that the UK Government has signalled that they will bring forward amendments to build upon the existing safeguards in the bill. So I would support proceeding with this right now, but I would expect the Government to be returning to committee in due course.
Okay, thank you, Cabinet Secretary. Jamie Hepburn, you want to come in?
It strikes me that there's two ways to look at this, and I could see some colleagues making, giving some sort of indication, well, this isn't going to have royal assent until autumn, so why the urgency just now. I suppose I would take the counter view and go back to the point. We are being asked to give legislative consent on a very narrow basis, and what we're asked to do here is to give indication to the UK Government insofar as the Scottish Government's, the Scottish Parliament's interests relate to devolved matters around, and it strikes me the most fundamental is the issue of the Lord Advocate's independence. We are satisfied. I would reflect on the point the Cabinet Secretary has made. This Parliament will return to this matter, and if there are wider issues that impinge and touch on devolved competence that relate to the very legitimate concerns I think Mr Mountain in particular has raised, but also Liam as well, it strikes me that this Parliament will have plenty of opportunity to say yea or nay in terms of legislative consent around those other matters. So I completely understand the instincts as well. You know, we've still got time here, and I suppose I would go back to the point. You know, the UK Government, in my experience, is not like to say, well, we're just going to stop and wait till the Scottish Parliament have consented to this element. So it's really just us giving an indication for this narrow area that we're satisfied, but clearly we can return to this subject in due course. So on that basis, I would suggest that we indicate that we support this particular area at this time.
Okay, thank you very much. So if there are no other members who wish to come in, I certainly acknowledge all the points that have been made by members. I think we've covered quite a range of different aspects associated with the LCM, and I'm very grateful for that. And like Jamie Hepburn, I'm grateful for the clarification, particularly around the role of the Lord Advocate that flows from this bill. I think just on the basis of the different viewpoints that have been shared in committee, I think there are perhaps two options. We continue with the process of seeking agreement with regard to the LCM, or agreement that the LCM should be agreed, or we can hold off making a recommendation, but instead, or we can do that, let me say, but also highlight some of the points that have been raised in the discussion today in our report to Parliament that we will compile following this session, and really maybe seeking further information, clarity, or any other points that members wish to raise. So can I propose that we proceed with considering approval, but we set out our position in our report to Parliament? Do members agree to that course of action?
Just so I'm clear on what I'm agreeing to. So we are being asked to recommend in writing to our colleagues in full Parliament that this LCM is passed by full Parliament.
Not quite. What I'm proposing is that we proceed with the formal process that we're about to go through. Sure. Obviously, if there are members who do not wish to agree, then we will go to a division. But that we thereafter make sure that the points that have been raised in committee today by members are set out in the report that we share with the Parliament.
Forgive me, Convener, I still don't understand. My position is simply that I don't think I don't feel able to say to my colleagues in full Parliament, I think this LCM should go through, because I don't. I think we should take time. So as long as that is somehow clear, then I'll do whatever I need to.
Okay, thank you for that. I'll bring in Stephen just to make sure that I'm covering the sort of technicalities of the process.
Thank you, Convener. So if I understand your proposal to the committee, it's to carry on in the usual fashion for LCM, ask the Cabinet Secretary to move the, or put the question on the issue of recommending consent to the, to the Chamber. And depending on how the committee agrees, that would be reflected in the committee's vote and obviously in the report. And additionally, if I understand conveners, to reflect the views expressed by various members. However, the question of when the legislative consent motion itself is taken in the chamber is more a matter for the Minister for Parliament and Parliamentary Bureau, and it's my understanding that that question is not going to be put this session. That will be a matter for session 7. So in effect, what the committee is being asked to do is to recommend that the Parliament, and we're now talking about a future Parliament, gives consent to the particular provisions in the Cabinet Secretary's motion at this point, but reflecting the views of different members in the report. So you're highlighting to a future Parliament what different members have said and some of their reservations around that process.
Clear?
Yes.
Good.
Thank you.
Okay. Fulton McGregor, very quickly.
Those views that you're referring to there only be GOF committee members or also include what Mr Mountain's brought to the table today?
That would include Mr Mountain as well. His views are on the official report, so the clerks with the convener would be reflecting the flavour of the debate today and making reference to the full official report that a future Parliament could read.
Jamie Hepburn.
Just very quickly, and I suppose maybe I'm reiterating the point, it strikes me as a very sensible way forward, convener, because it does strike me that the concerns that have been raised probably stray slightly wider than the strict area we're being asked to provide legislative consent to. So I would be very content. I think it's a very sensible thing for us to do, to say, yes, we're happy to recommend legislative consent to this narrow area. Here are some wider issues around the bill that we think Parliament still needs to reflect on. I think that's a perfectly legitimate and sensible thing for us to do.
Okay, thank you very much. Katie Clark.
Thank you. And I would be minded to support the legislative motion before us today, given the nature of the content of it, which seems to relate to the gathering of evidence, biometric evidence, legal representation expenses, evidence and records. So it seems relatively ancillary matters rather than perhaps the principled issues which Mr Mountain has been raising with us today. I was, however, surprised when I heard that we wouldn't be voting on the motion this session, and it would be helpful to get a little bit more thinking on the reasoning of that. And I appreciate that may not be something that has been something that the Cabinet Secretary has been involved with. I presume the reason may be that we may not have a committee system up and running when the Parliament resumes, and it may take some time. And I know from the experience of the beginning of this session it took a number of months, so therefore the motion would be going straight to the Parliament in any event. That's the only reason that I can think there would be an argument that we should deal with it in this committee to report to the next Parliament, because ideally you would have imagined that a committee of the next Parliament would look at the issue so that the members involved in that scrutiny could then take part in the wider parliamentary debate, and it would be helpful to get that clarified, what the thinking is. I appreciate it may well not be people in the room that have that information. As I say, I was minded to vote in favour of the legislation today.
Okay, thank you very much. Thanks for those comments to all members. I can't answer that final question, but I'll maybe bring in Stephen again, just if you've got any...
Yeah, just to the extent that I can answer it, because as I say, the questions around scheduling of the legislative consent motion for the Chamber is a matter for the Minister for Parliament and the Parliament Bureau. It's my understanding from the business team, that's the Parliament's business team, that it's not currently scheduled this side of the campaign recess. I don't have any details of when that might be scheduled in session 7. That would be for the new Parliament and a new Bureau. Ordinarily, committees are normally established within 2 to 3 weeks of a next session, but it may take longer. I don't know for sure. That's a matter for new Parliament and negotiations between business managers next time round. So I will try and find a little bit more information out for members as to the intent for scheduling. But as I say, these are mainly matters now for the next Parliament and a new Parliamentary Bureau. But the question around why not this session, I'll certainly ask the Minister for Parliament's office for an explanation if they're able to provide one and provide that to the committee.
Okay, thank you, Stephen. Okay, so if we can move on then, if I can ask the question, is the committee content to recommend to the Parliament that consent should be given for the relevant provisions covered by LCM S6 number 68 and LCM S6 number 68A? Are we all agreed?
No.
We are not agreed. Therefore, we'll move to a division. So if I can ask members who are content to recommend that consent be given, raise your hands. Thank you. No, it's no, because it's an LCM, isn't it? It's an LCM.
That's fine, okay. Sorry.
Yeah, just it's a recommendation to the committee. It's not an affirmative SSI, so we don't need the Cabinet Secretary to move the motion in the same way as we would for an affirmative SSI. So this is a recommendation to the committee. You might want to rerun the vote again.
Okay, so
Apologies.
in that case then, can I... We'll go back to the beginning. I think that might be easiest. So, is the committee content to recommend to the Parliament that consent should be given for the relevant provisions covered by LCM S668 and LCM S668A? Are we all agreed?
No.
Okay, we're not agreed. Therefore, we will move to a division. So, can I ask members who are agreed, are content to recommend to the Parliament that consent be given? Raise your hands. Thank you. Those who are not agreed to recommend to the Parliament that consent be given, raise your hands. Thank you. And we have no abstentions. Okay, so the result is that there were 5 votes in favour of consent being recommended, 2 votes against. Therefore, we are agreed that consent should be given. So, are members content to delegate responsibility to myself and the clerks to approve a factual report outlining the points that have been raised today to the Parliament on the LCMs?
Yes.
Thank you very much. Okay, so in that case, I thank the Cabinet Secretary for attending and will suspend briefly just to allow a changeover of officials. Thank you. Okay, thank you very much, members. Our next item of business today is an oral evidence-taking session on a supplementary legislative consent memorandum for the UK Government's Crime and Policing Bill. And in addition to the Cabinet Secretary for Justice and Home Affairs, I welcome Yvonne Edmund, International Justice Cooperation Team, Patrick Down, Criminal Law, Procedure and Sentencing Team, and Jim Hislop, Organised Crime Unit at the Scottish Government. So welcome to you all, and I refer members to paper 2. I intend to allow up to 15 minutes for these items. So can I invite the Cabinet Secretary to make some opening remarks on the LCM.
Thank you, Convener. I'm here to speak on the UK Government's Crime and Policing Bill, where new clauses have been added, which again trigger the requirement for legislative consent. I appeared at committee on the 1st of October last year to give evidence on LCMs lodged in May, June and August 2025. I then attended committee for the second time last month on the 25th of February to give evidence on the supplementary LCM lodged in December 2025. Following this, the Criminal Justice Committee recommended to Parliament that consent be given for the provisions covered by those LCMs. At committee last month, I set out that a further supplementary LCM was anticipated. Since then, we have lodged our 4th supplementary LCM on the 2nd of March this year, covering the issues of remote sale or letting of knives and the application of the definition of law enforcement employer and the advisory lists for the Civil Nuclear Constabulary and the British Transport Police. These amendments bring benefits to Scotland, and therefore the Scottish Government is happy to recommend that Parliament provides legislative consent to the relevant provisions within this bill. Clauses 31 to 35 in the bill relate to where knives and crossbows are sold remotely. Remote sales include online sales, but also things like mail order sales or sales by phone. Essentially, the concept of remote sales captures sales which are not made face-to-face, for example, sales not made in bricks and mortar shops. Age verification is a key element of knife and weapon sales, and this presents distinct challenges when a sale takes place remotely. In addition to the challenge itself of verifying age when the sale takes place remotely, there is also the process of delivery of the item where an increased risk of bypassing age verification arises. The amendments to clauses 31 to 35 extend across all the nations of the UK, so there is one system in place for retailers, delivery firms and businesses operating as collection points. The effect of the amendments is to strengthen the specific requirements on age and identity verification at the point of remote sale and at the point of delivery collection. The amendments provide the Scottish Ministers with powers to prescribe by regulations steps which a retailer, delivery firm or collection point operators may take to verify a buyer's age and identity. In addition, a new offence of delivering or handing over a package containing a knife or crossbow to someone other than the buyer is created. This means knives and crossbows can never be left, say, with a neighbour or collected by someone other than the buyer. They must be delivered or handed over direct to the buyer. This strengthening is needed to reduce the risks of weapons getting into the hands of underage individuals and follows a recommendation from a UK Government-established independent review. Although this area of law has devolved, the policy extends to Scotland, as we consider it as a sensible approach to have UK-wide laws to ensure robust enforcement can occur to avoid any cross-border loopholes arising, which reflects the nature of many retailers and delivery companies operating within all the nations of the UK. The amendment to clause 179 looks to include law enforcement employer so that it is consistently applied across clauses 173 to 178. The amendment to Schedule 21 of the Bill seeks to remove the requirement to include in the advisory list of the Civil Nuclear Constabulary and the British Transport Police those civilian employees who are retired or resigned before allegations came to light. A number of amendments were also tabled which do not require the consent of the Scottish Parliament because they are technical amendments to clauses that have been covered in previous LCMs. These amendments remove the reasonable belief test from child criminal exploitation offence, make minor drafting amendments to the provisions regarding child sexual abuse image generators, and make provisions for pre-commencement consultation on police access to driver licence information. The measures in this fourth supplementary LCM align with Scotland's policy priorities, and the legislative consent of the Scottish Parliament is essential if these measures are to take effect in Scotland. And I hope that brief overview is helpful, Convener.
Thank you very much indeed, Cabinet Secretary. So I'm now going to open up to members for any questions. So if you'd like to come in with any questions, just let me know. No? Nobody want to come in? Okay, thank you very much. Does anybody want to make any points about the LCM before we move on? No? Okay, thank you very much indeed. So, in that case then, is the committee content to recommend to the Parliament that consent should be given for the relevant provisions covered by LCM S6 57D? Are we all agreed? We're all agreed. Thank you very much. And are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the LCMs?
Yes.
Okay, thank you very much. So, as this is our last scheduled meeting of the session, can I thank the Cabinet Secretary and all your officials who have attended committee and given evidence to us over the last 5 years. We're very grateful and thank you very much.
Thank you very much, Convener, and to all other colleagues across the party divide. Also, it's always been actually a good experience, if not at times very thorough and robust. And it's been a pleasure to attend committee.
Thank you very much. So I'll now suspend the meeting again for a few minutes, just to allow a changeover of witnesses. Thank you. Okay, thank you very much indeed, members. So our next item of business is an oral evidence-taking session on an affirmative instrument which has been relayed by the Scottish Government. And this is the Antisocial Behaviour Fixed Penalty Offences Miscellaneous Amendment Scotland Order of 2026. So we're joined this morning by the Minister for Victims and Community Safety, and I also welcome to the meeting Robert Wiley, Policy Lead, Safer Communities, and Fiona McDermott, Unit Head, Safer Communities, both at the Scottish Government. So welcome to you all, and I refer members to paper 3. So I intend to allow up to around 15 minutes for this item, and can I invite the Minister to make some opening remarks on the SSI and perhaps set out the reasons for this being relayed. Minister.
Yes, good morning, Convener, and good morning, Committee. And firstly, can I just take time just to apologise to the Committee under the circumstances that I am back here today. I totally appreciate time is of the essence where we are in this parliamentary term, so just apologies for that. As the Committee knows, the instrument relates to antisocial behaviour fixed penalty notices. This regime has remained unchanged in important respects, such as the penalty level, since it was introduced back in 2005. Police Scotland approached the Scottish Government to ask for this work to be undertaken to modernise this regime, in particular to introduce the offence of threatening and abusive behaviour into the regime. We brought forward the original draft order following discussions with partners, including Police Scotland and the Crown Office. The purpose of the order, as you know, was to make a series of targeted changes to keep the regime up to date. As part of the policy development work, government officials reviewed the offence list and proposed removing 2 offences from the regime on the basis of apparent non-usage. Although Police Scotland supported that proposal, we have now identified that the understanding we all had of recent usage data for one of those offences was incomplete. The earlier conclusion was informed by an interpretation of the criminal proceedings in Scotland data that did not fully reflect in ways these offences are categorised in the published statistics. 43 equivalent notices for the Section 115 offence under the 2005 Act were issued in the most recent reporting year, with a similar volume recorded in the preceding year. In the published statistics, these FPNs are classified alongside other 2005 Act offences. So I'd like to apologise to this committee for that error. Officials have reviewed how it arose, and clear lessons have been identified to mitigate against this happening in the future. Officials have discussed the corrected position with Police Scotland, and I'd like to reassure the committee that the police considered that even if we had proceeded with the original proposal, they would have still been able to deal effectively with the types of cases they encounter that involve disorderly behaviour whilst drunk in licensed premises. However, I want to acknowledge the concerns raised by the members in the previous session when I tendered about removing the offences based on a relatively short period of apparent non-use. And I appreciate that these were legitimate points, and I have reflected on them. And having considered the complete time series data and the committee's remarks, I've therefore brought forward a different legislative approach through this revised instrument. It allows us to make progress in the areas where there is strong evidence and broad support, while pausing the proposed removal of offences so that they can be considered as part of the wider review of antisocial behaviour legislation that we discussed previously. The revised instrument focuses on 2 amendments. First, it increases the FPN level from £40 to £70, restoring its real-term value. And secondly, it adds the Section 38 to the ASB FPN regime. And Section 38 is now routinely used for lower-level conduct and is already eligible for recorded police warnings. I want to emphasise that the ASB FPN regime is operated by police using their discretion within a clear framework of safeguards. The Lord Advocate's guidelines on direct measures set out the limits on the use of ASB FPNs, requiring consideration for victim impact and provide for monitoring and also for annual reporting. Convener, I hope that this revised approach demonstrates that we have listened carefully to the committee and responded proportionately due to the circumstances. And I just want to apologise again for the need to come back to the committee, and I thank members for all their patience.
Thank you very much, Minister. And I think we're committee's grateful for the update that you've provided, the explanation given, and just for setting out some of the detail in relation to the provisions brought forward in the SSI. So, can I invite any questions from members? Sharon.
Thank you. Good morning, and thank you for the opening statement. I'm wanting to go back to, obviously, you were here before on the 18th of February. You've obviously said that some of the figures were incorrect, but I'm wanting to go back and find out how we actually got the SSI coming to the committee in the first place, because obviously it's already been to the DPLR committee. It's then came to us. We've done questions in committee, but we've taken it in trust, and we were going to put it through, which would have meant it would have went to Parliament, it would have been voted through into legislation. So who is it that prepares the SSI, and why were the figures not verified before, firstly, it went to the DPLR committee and then came to our committee?
Yes, so obviously we wanted to reform this part of the fixed penalty notice, and that's why it did come to the SSI. Obviously, there has been a mistake in the data that has been collected. I might bring Bob in, if I can, maybe because you'd be in charge of doing the SSI, just as how the statistics were incorrect.
Yes, so as the Minister described, Police Scotland came to us with a request to add Section 38. We then engaged in discussion with Police, Crown, British Transport Police to try and understand their needs. And we looked at data as part of that. We commissioned economists to look at what the right level of penalty level was, and as part of that, we identified that we perceived there to be 2 offences for which no FPNs were used in the previous financial reporting year. As part of an instrument, the purpose of which was to bring practice up to line with current practice, we considered that it was appropriate to remove those offences as a result. We reached out to partners to ask for their views, and Police Scotland, among others, replied saying that they were supportive, and that was the basis on which the instrument was presented. There was an error in the interpretation of those statistics, as the Minister's outlined, and going forward, it is effectively impossible for that to happen again, because wider changes to the FPN regime will happen and will need economist input and involve much bigger potential changes, such as gradations of penalty level or introduction of new offences, fraud and trespass on the railway has been suggested by a group that's recently reported to ministers. So all of that will need a different process, the potential for public consultation in a way that this instrument was not really designed to do, because it was designed to just bring the system in line with current practice as much as possible. So that was the basis on which the error was made.
Can I just come in just for a clarity, because one of the things, my understanding is on how the mistake has arose is how officials have interpreted the data, which does not fully reflect these offences, are categories in published statistics. And I know this is quite confusing, but the heading righteous behaviour while drunk in licensed premises only covers the 1976 Act of Offences. And there is an equivalent offence in the 2005 Act, Section 115, and it's grouped under a different heading, which is refusing to leave licensed premises. Then, because of the structure of the 43 ASB FPNs issued last year were under the Section 115 and not included under the old heading. That's where there's been some confusion. So that's where it's been picked up, and things have been put into place to ensure that this never happens again, because it's just been categorised as different offences in different areas.
So the increasing of the fine, I don't think was ever an issue when we were at committee last week. I think we all were in agreement of that. And adding the extra offence in was never an issue as well. It was the whole process of how we went to take 2 offences out. So And we said that in preparation of the paper, you engaged with Crown Office and Procurator Fiscal Service, and you engaged with Police Scotland. I think you've just said there that you also engaged with economists and British Transport Police as well. So who was it that actually asked for the offences to be removed? Because again, there was only 2 years where they hadn't been used, which in legislation is quite a short period of time. I mean, there's legislation that we pass in here that doesn't even get implemented in 2 years' time. So I'm just wondering who it was that decided they were going to take the offences off, and why did nobody question it? You said that we perceived that it didn't need to be in there, so who was we? And you reached out. So did you actually have any in-person meetings, or did you just send an email? I'm just wondering how it happened.
Well, I'll have to bring officials in, because my understanding is when I met with officials before, obviously we came into the committee, the SSI was really updating it, because for the last 2 years it was declared that there hadn't been any offences and that it had been liaised with Police Scotland, and no one had brought up this as an issue. So that's why it had come forward. It's only afterwards, and then we had this committee that then it was looked into, and then it was found that it had been under a different category, so there were offences. And this is why I'm back here today, as I listened to the committee to ensure that it's only the increase in fees in the Section 38 now added, and when we move into next parliamentary legislation, when we're doing the broader work on antisocial behaviour and fixed penalty notices, then that will be included at that stage.
So I suppose that still goes back to I'm looking for another answer, because you've had information that's been given to you, but it's the officials that have went out and had all of these meetings and then presented you with this. So you've obviously taken it as fact as well. So what I'm trying to get is, we've got the Crown Office and Prosecution Service, we've got Police Scotland, we've got British Transport Police, we've got economists, we've got all these government officials, and you're wanting to bring to this committee information that's incorrect, and you want us to go in and change legislation. So I'm just trying to get, we come into committee and we expect the information that we're getting to be factual. So I'm just trying to get to the bottom of what investigation is going to be done into how we were given incorrect information to then take to Parliament.
I don't know, Bob or Fiona, who wants to come in?
Yeah. I think that we can... so the proposal to remove offences was suggested by government officials. That's the answer to your previous question.
Sorry, and just on the basis of it not being used for 2 years? On the basis of it, yes, that's right. It was suggested that, is this in line with current practice? Is it needed at the moment currently? We propose that it be removed as a result to bring it in line with current practice. In a context where we're adding Section 38, is this a sensible measure to bring it up to date? In answer to the investigation, there have been quite intensive investigations both at policy level and with statisticians about what we can do to make sure that this doesn't happen again. And so, as I've alluded to, the future policy work that is going to take place on antisocial behaviour fixed penalty notice regime is going to be done in a very different way. So it won't be possible for this to happen again. In addition, I know that statisticians are looking at the way in which information about ASB FPNs is presented in the future in criminal proceedings in Scotland statistics, in order that, again, there can be learning from this. So there have been investigations to try and get to the bottom of what's happened and to make sure that this doesn't happen again. And I think we can provide assurance that with those guardrails, I suppose, that we've got now for future work, that won't happen, that we won't be in this situation again, if you see my point.
And if can I just add, I think like in the close to 3 years of me being in this position, I've never had this happen to me before, so it's not something that happens all the time.
Not that we're aware of, so hopefully there isn't any more. In the 18th of February as well, it said that Police Scotland did not want the offence of being drunk in charge of a child to be removed from the ASB FPN regime. So why did we proceed with taking it out?
Sorry, what was that data?
You said that Police Scotland did not want the offence of being drunk in charge of a child to be removed from the ASB FPN regime. So that's in the official report. So why did we proceed with taking that offence out in the SSI?
I can't remember that being the Police Scotland saying that they didn't. It might be misinterpreted.
I don't know if it's helpful to...
To the SSI that we're dealing with
When we
today.
engaged with the police in the instrument, it was not an issue that they raised, but they wanted that offence to be kept on the list.
No, I think that's a misunderstanding. Police Scotland are quite clear that being drunk in charge of a child is not something that they would look to issue an ASB-FPN on now.
And there was quite a lot that had actually went to court. I've seen that in updated figures. Yeah. Okay.
Okay, thank you. Jamie Hepburn and then Katie Clark.
I think clearly this is unfortunate. I'm inclined to recognise and understand it as unusual. Certainly my own experience, things can go wrong, but it doesn't happen over. I suppose my own reflection would be one of the things that we were reassured by at the time we did agree to the previous instrument was the clarity that the various offences that were being removed could still be prosecuted under, I think it was common law and other offences that are specified in legislation. It would be useful to understand what will be happening going forward. Because if you've brought this forward, this rectifies the particular problem. I think we all accept that. So, you know, you've recognised it, you've let the committee know, which I think we all appreciate, and this new SSI deals with that, which I think is welcome. But useful just to understand what will happen going forward. And I suppose the first question might be, you know, would it be better and safer to operate a presumption against removing offences rather than looking at it the other way around and saying, you know, what should we remove, and being reassured that, you know, there's maybe an equivalent offence or something has maybe superseded it and replacing it, which I think is what I understand is happening here. But I'm particularly interested, and you know, it might be that you don't want to go into a lot of detail right now, Minister, but maybe provide it in writing that you're very clear that this will not happen again, because clearly processes have changed. Mr Wiley has used the term guardrails, so, you know, we can get some form of sense as to what that might mean, but I think I would be reassured if we could maybe get a bit more information as to what steps have been taken, what measures have been taken, using this as a learning experience to make sure that it won't happen again.
Member for that, and I think one of the things, just for your first part of the question, is what will be happening moving forward. I think the next parliamentary term, I can't speak on behalf of any government, but obviously we do know that there's antisocial behaviour legislation. We had the report. There's a lot of work that should be done in the next parliamentary term in relation to antisocial behaviour and maybe rehaul of the fixed penalty notices as well. And I think the presumption about the current ones, I think that's something that definitely can be considered, because I think what's happened here, lessons have to be learned. I have been reassured by, obviously, I don't want to be here today, and I have been reassured by officials that lessons have been learnt and things have been put in place, and I'd be happy for officials to write to the committee to explain what procedures have been put in place and safeguards to ensure that this never happens again.
Okay. I mean, can we get, I'm not looking for it in massive detail, but can we get some form of sense of what that looks like at this stage, and maybe follow up in writing a bit more detail? Is there a wee bit more information as to what we can find out just now?
What safeguards are in place to ensure that this doesn't happen again?
Speak about the broader review that this work is going to be folded into. So at the moment, officials are, for example, undertaking site visits with local authorities, and community policing teams is forthcoming to try and understand how all of the powers in the Antisocial Behaviour Act are being used in practice, what works and what doesn't, with the people who are on the ground who are using these on a day-to-day basis. On fixed penalty notices specifically, very shortly there's going to be an initiation meeting to make sure that broader work about changes to the regime has analytical input from the beginning. We have a whole series of quite big issues of principle that need to be addressed about the regime, graded penalty levels, addition of, as I say, the suggestion has been made around about addition of low-level ticket fraud. There has not been the suggestion of any removal of offences. If that's any further assurance, I suppose, that we won't be looking to return to the question of removing offences from the regime on our own behalf.
The Scottish Government's legal directorate be more involved? And it sounds to me the issue here has been there's not been enough cross-reference to different forms of legislation.
Yeah,
You know,
if I can just come in, that also note some of the other proposals for reform to the regime are going to be more complex moving forward and involve questions of principle and different penalty levels. So what we have in place changes on both the statistical and the policy side that directly address the cause of this error. And the statisticians are reviewing similar clarifications across the bulletins, and policy processes are now included strengthening verification and cross-checking. And with these safeguards that have been put in place since we've been alerted to this specific circumstance that led to this mistake should not recur.
so cross-checking of different items of legislation is the...
That's what, yes,
Okay.
I'm being told.
Okay.
Thank you. Katie Clark.
So the instrument that we have before us today is simply adding an offence where a fixed penalty notice could be issued, as I understand it, and also increasing levels of fine. And I would be minded to support that today. In terms of the wider issue and the history and the broader review that's been referred to, I think it's fair to say that many of us were concerned that officials, as it has been said, were looking for offences to abolish, because usually it's helpful to have a range of offences that are available so that the police and prosecution services have a range of options, and that's just as a general position. So I think that would be helpful if that could be fed back, that at least some of us are of that view, that we're not necessarily expecting proposals for abolishing offences, but I take on board the wish to review whether the legislative framework works and actually delivers on the policy objectives. So I don't have any questions. I just really wanted to put that on the record so that you know that at least some of us are very much in that position. So if this was coming forward in the next Parliament, it may well be that others would be making those points. So I hope that's helpful. But I would say to the Minister that in terms of the proposals today, they seem to me to be perfectly acceptable. So I'm pleased that we've ended up in this place and that she's brought all this to the committee.
Thank you.
Okay. If no more members wish to come in, our next item of business is to consider a motion to approve the affirmative SSI, in which we've just taken oral evidence. So can I remind officials, and note that you need reminding, that only MSPs can speak in a debate on a motion. So can I invite the Minister to move motion S6M 20475 in her name and make any brief additional comments she wishes to make?
Thank you, Convener. I move that the committee recommends that the antisocial behaviour fixed penalty offences miscellaneous amendment Scotland Order 2026 be approved. And I've got no further comments, Convener.
Okay, thank you very much. Do any members wish to come in with any final comments? No? Sharon Dowie.
Thank you. Just to say, I'm going to support the SSI when we're going through. The one thing that I should probably bring back in, last time when we were in on the 18th of February, I'd mentioned about the impacts of possibly raising the fine level, which I do agree with, but to make sure that we monitor any non-payments. So the figures that were sent back through for this one say that there's 2,903 non-payments in the previous 3 years. They're taking off 501 of them that were for coronavirus. It still leaves us with 2,402, but taking that off, it still does show that there's an increasing trend of fines that are not getting paid. So with the increase, it was just to make sure that the government is going to monitor fines that are not getting paid to see if this does have an impact. And again, just reiterating the fact that when we come to committee, we rely on the information that we're been given is correct before we put SSIs through. So I just hope that officials reflect on that and make sure that the information that they're passing to government ministers is correct, to make sure that we're not putting things into legislation that we shouldn't be. Thank you.
Okay, thank you, Ms Dowie. Okay, can I therefore invite the Minister to wind up and press or withdraw the motion?
Press convener.
Thank you very much. So the question is that motion S6M 20475, that the Criminal Justice Committee recommends that the Antisocial Behaviour Fixed Penalty Offences Miscellaneous Amendment Scotland Order of 2026 draft be approved. Are we all agreed? Yes. Thank you very much. And are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instrument? Yes. Okay, thank you very much. So this will be published shortly. So, as this is a last scheduled meeting, can I thank the Minister and your officials for all your contributions to committee over the last 5 years. It's greatly appreciated. And that concludes our business in public today. Before we move into private session, can I take this opportunity to thank all of the members of the committee, my colleagues, past and present, for their excellent work this session and the very collegiate way that they have approached the business before us. And may I also extend our thanks to our wonderful team of clerks and also our wider group of staff who have supported us, including Spice, Official Report, Broadcasting, PACT, media teams, security, catering, and anyone else that I have forgotten. And finally, can I thank all of the witnesses who have given evidence to us over the last few years, particularly those for whom it has been challenging to come and talk to us about their experiences, some of which have been serious and traumatic. It has meant a great deal to the committee and it has contributed a great deal to our work. So, for the very last time, before I start to cry, we now move into private session. Fulton, I'll bring you in first.
Thank you very much. And I think it's probably worthwhile saying as well, you forgot one person to thank, convener, because it would be pretty difficult for you to do so. So I'm sure I speak on behalf of all colleagues and clerks, thanking yourself for the brilliant way that you've convened this committee over the last 5 years.
Thank you, Fulton. It's been an absolute pleasure. Okay, so I now close this meeting and we might move into private session. Thank you.